Kassotis. Yesterday, he took a stand and tried to convince the jury that he didn't kill his wife, Mindi. Well, The defendant here, Christopher Wolfenbarger. Opening statement's about to begin. You can see him wheeling in on his wheelchair, shuffling in as he gets ready for the opening statements. He's standing trial for a 25-year-old cold case. He accused of killing his wife, Melissa. He's able to move his wheelchair with his legs. You notice that? He's not using his arms. Before we head into the courtroom, here's Court TV's Cody Thomas with a backgrounder.
It's been a long wait, 25 years. But finally, hopefully, we will get justice for Melissa.
A Georgia man is now standing trial for the cold case murder of his wife, Melissa Wolfenbarger.
I've gathered the facts, and I collaborated with the DA's office and was able to get the facts together to come up with the probable cause to arrest Christopher Wolfenbarger.
We have finally made it. He's in custody. And now we just need to get over the last hurdle and get him convicted.
Christopher claimed back in 1998 that Melissa left on her own accord and never returned, but was arrested in August 2024, 25 years after Melissa's remains and severed head were found in trash bags.
I'm pretty sure it's domestic violence. He was captured in his home in Griffin. He hid. It took the detectives a little while to find him, and they found him, I believe, hiding behind a dryer.
Police also suspected Melissa's father, Carl Patton, a serial killer who committed 5 murders across Georgia from 1973 to 1977. News Nation's Ashley Banfield spoke with Melissa's mother about his reaction to the arrest of Christopher.
He was devastated when he found out she had been murdered, but he was deliriously happy as soon as he found out Chris had been arrested.
Christopher, who has pleaded not guilty, now faces life in prison for the murder of his wife, but her family says they knew since day one that he was responsible.
From day one, we knew it was Christopher. There was never, ever any doubt in our minds who did this.
All right, there's a live look inside the courtroom. They're hashing out some preliminary details before they bring the jury in for those crucial opening statements. We'll get a real feel for both sides, where they're going to go with this. Will the defense use the fact that the victim's father was a serial killer to their advantage? Maybe point the finger at him, even though he was obviously looked at when she went missing. Let's bring in Sunny Slaughter. She's a law enforcement expert and civil rights attorney. Dante Pointer's joining our discussion. Hey, good morning, Dante. What's your take on this bizarre sort of, maybe just complete coincidence, I think it is, that the victim in the case has a father who's a serial killer, and now her husband in a cold case is accused of murder and dismemberment? What's your takeaway, and what are you expecting in the openings that are going to be happening very shortly?
Yeah, well, the opening statement is a roadmap for the jury to understand what evidence they are expected to be presented with, as well as the theme of the case, should the prosecution offer one up, which they oftentimes do. From the defense perspective, you're using opening statements, if you elect to do one, as a way to also explain away the evidence and or set the stage for reasonable doubt, which you're hoping is going to help either reduce or eliminate some of the charges and or help you walk your client out of court. So opening statements are critical as it relates for both sides, laying out to the jury what they're going to be expected to hear as it relates to testimony and evidence throughout the trial. And it's the attorney's first opportunity, if you will, outside of voir dire when they were screening jurors, to really build the credibility, not just for them as the attorney, but for their client and ultimately for the decision they are working for the jury to render in favor of their client or of the people, if you're the prosecutor.
Sonny, the bizarre coincidence here, Carl Patton, the serial killer, his daughter goes missing, and now his ex-son-in-law is facing murder. I love that the fact that Norma Patton said that Carl was deliriously happy when he found out that Christopher was charged with murder, no honor amongst killers, I guess. Your thoughts overall on this, weird case?
You know, Ted, I was thinking the same thing. I don't know if you heard what I said. Oh, that's interesting. So the serial killer father is glad that the person who murdered his daughter has been captured. So maybe they will be cellmates of some sort. You know, I have to give kudos to the cold case team, to my law enforcement colleagues. I was just with law enforcement cold case team of Memphis, and we were just on Monday talking about the complex nuances of putting these cases together for that can finally get to prosecution, and having to ensure all of the evidence is crystal clear so they can move forward in the court case, because it's very difficult with all of the details so many years later, and we're talking 1998. So this cold case unit has really been working hard. I'm sure they had to get fresh eyes on and off, but I'm glad they were able to at least bring this part to the criminal justice system, and these cases are very difficult. So congratulations for at least doing what they are put in place to do, and that is to at least try to obtain some form of justice for the victims in these type of cases.
Again, we're just waiting for some preliminary items to be hashed out in the courtroom there. Dante, to Sonny's point, 25 years, long time, and these are inherently difficult cases to prosecute and win. Then you add the fact that the victim's father was a serial killer. It can bring up potential reasonable doubt amongst jurors if the state's case isn't lock solid, because you could go, if the defense brings it up, and maybe we'll hear it in openings, get it into the juror's mind, well, the dad was a serial killer. He had probably had lots of enemies, blah, blah, blah. You can go down a rabbit hole there. How difficult could this case be for prosecutors, given the inherent limitations on a cold case?
Well, you know, prosecutors have a steep hill to climb with a cold case and a cold case prosecution, because the evidence, witnesses, all of the really important and critical items that would be presented to the jury in order to prove up a case are very old by their very nature. It's a cold case. And so what the prosecution is going to be trying to do is warm up that evidence, warm up the testimony, and trying to find and marshal witnesses who may have given a statement, in this case, 20 plus years ago, to remind them and to refresh their memory, and also to put them in a moment so that their testimony is compelling. On top of that, just to go to what you mentioned, if I'm the defense attorney, I'm certainly spending a lot of time leading up to this trial, figuring out how I'm going to point to the victim's father, okay, as the potential and as the person who did this. He's a convicted serial murderer, and yes, he may have a lot of enemies who wanted to come back and inflict the same harm upon him that he inflicted upon the community. On top of that, if he's also been suspected of other murders but have not been solved, then you could almost say, hey, you can add this to the case of potential things that he's done that he's up till now gotten away with. And hey, jurors, don't let him get away with this one. And so I can see it being compelling if the defendants are able to marshal some sort of credible argument to say, hey, I'm going to point to this empty chair right here beside my client. And you know who should be in this chair? It should be the father, not my client. Let my client go. We should be looking at this father. So I think there could be certainly a battle royal of sorts between both sides in terms of trying to exclude the father, and from the prosecution's perspective saying, we have our guy right here in front of you, jurors, and this is the evidence, and we're going to lay it out for you. And you'll see at the end of the day, we need to put this guy behind bars for good.
Yeah, we will find out momentarily in the openings how the defense is going to approach this, and whether or not the state will even bring up Dad, the convicted serial killer, in this case, Carl Patton. Let's get a break. When we come back, we'll watch those opening statements soon in the killer's daughter murder trial. Plus, we're on verdict watch in the dismembered wife murder trial. There's a live look inside the courtroom. What will the jury decide when it comes to Nicholas Kassotis? We're waiting. Stay with us.
Matriarch of the Adelson family gets arrested.
Terrible.
Donna Adelson is facing charges of murder, the death of her former son-in-law, Dan Markell.
Prosecutors say a bitter child custody battle was the motive for the murder-for-hire plot.
Now that Donna has turned into a defendant, what's next for the Adelson clan?
Now that the ship is really sinking fast, blood doesn't matter that much.
The Matriarch Mastermind murder trial. Live coverage begins next week, only on Court TV.
Welcome back to Court TV Live. I'm Ted Rowlands in for Julie Grant on this Thursday. Busy day here at Court TV. You got the Kassotis jury deliberating. Other court cases also that we are tracking this morning in Arkansas. Defendant Andrew McGann expected to enter a plea this morning. He's accused of killing a couple that were hiking with their children at Devil's Den State Park in Kentucky. Defendant Felicia Gross entered a not guilty plea this morning. The mom charged earlier this week in the death of her 10-year-old son, Jaden Spicer. And in Georgia, opening statement set to begin at any moment in the killer's daughter's murder trial for Christopher Wolfenbarger. He's standing trial for the 25-year cold case murder of his wife, who was the daughter of a convicted serial killer. Let's go into the courtroom. That is where the parties are talking about the victim's father. What part, if any, will he play in this trial? They're hashing it out right now. Let's go in and listen to these arguments outside the presence of the jury.
Anything else there was a motion in limine that was filed by the state, I think last night. And I need some help with it because I wasn't quite sure I understood what we're trying to limit. Obviously, we've understood for some time now that the fact that Carl Patton is a convicted murderer, right, was going to come into evidence in some manner, right, that was going to be an issue in this trial. So I'm not exactly sure what you're asking me to allow or to forbid. Can you help me, Mr. Fawcett?
So I guess as laid out in the motion, this is, as of the past week or so, I think it kind of gives me some insight into what possibly could be asked or attempted to elicit during the course of the trial. And as I've laid out, the only reason why Ms. Melissa Wolfenbarger's father is relevant for this case is because his arrest really jumpstarts the identification of her. And I don't know when she would have been identified, but for the infamous arrest of her father and him saying, "Find my daughter." That's pretty much what we've heard repeatedly by the medical examiners, the lead detectives, and everyone involved. But to take that information and now to attempt to introduce letters from Carl Patton, what I'm trying to avoid is a relitigation of the case involving the Flint River killer, because all the particulars of that case simply aren't going to be relevant for the determination of whether or not Christopher Wolfenbarger murdered his wife. So it's one thing to say, well, he was arrested. It maybe is relevant what he was arrested for. Maybe. But outside of that fact, and the fact that that arrest triggered the identification, that's what the detective, Bruce Jordan, was the notifier to the medical examiner's office of that missing woman, Melissa Wolfenbarger. That triggered the retrieval of the dental records from William Brantley. And that was the comparison that made the identification. So outside of that, what other relevant parts of the case would be admissible? I don't believe that the statements of Carl Patton would be admissible. I don't believe that the particulars of the case itself would be admissible. So I don't believe that the defense should be able to ask Norma Patton, well, tell me how many people did he kill? Tell me the circumstances of that. How is that relevant for whether or not Christopher Wolfenbarger killed Melissa Wolfenbarger? It just is not. And I think that in particular is something that confused the issues in this case, that confused the jury.
Okay. Mr. McDermott?
We disagree, Your Honor. We think that the only point of relevance being that he helped them identify who she was is just the tip of the iceberg. There's an entire developed body of case law which has been even more developed recently by the Supreme Court regarding evidence of third-party guilt. This is a classic whodunit case. The state has only circumstantial evidence that Christopher led to the death of Melissa. We have substantial evidence that there could have been other people who were involved in her death. And the Supreme Court has recently said the standard for third-party guilt is basically going to be 401, 402, 403. And they have telegraphed that in their most recent opinions. Even though it's not the precedent, I'll grant you, they've telegraphed that. They've said the test is going to be if this evidence makes it likely, tends to make it likely, using the I got on the top of my head the rule for relevance, more or less likely that he's
not,
guilty,
right? Yeah.
then it's relevant. And then it's only a 403 test after that. Well, Carl Patton's murders, it's not just he killed 5 people back in the 70s and that was it. It's why he killed people. It's his motives for killing people. It's who he killed, his friends and family. The way he killed them, wrapping them up in bags and dumping them in the river. It's the fact that he drove miles and miles to try to hide bodies. It's the fact that Norma Patton, who's going to be testifying here today, was right there hands-on helping him for 2 of those murders. She helped him. And what I intend to ask her about is only what she testified to in court. It's a certified court record that she helped. She helped plan the murders. She helped watch. She was in her living room. They shot the people. They fell. She helped clean up the blood. She helped carry the bodies out.
So let me stop you for a second and set what I think are going to be 2 signposts here before we get more granular, right? One is that Mr. Patton exists, that he is a convicted murderer, that he, I think, was briefly considered a suspect, although my understanding is obviously the state changed its mind and decided that it wasn't Mr. Patton. But all of those things are relevant, and I think that the state can't limit the relevance of Mr. Patton's existence and his history, right? Like how it's relevant to Melissa Wolfenbarger as a general proposition. Also, certainly, I fully expect that if Ms. Patton, Norma Patton, takes the stand, that there will be a thorough and sifting cross-examination about her involvement as a credibility matter, right, and as a convicted felon or whatever, charges she pled to. All of those things I think are absolutely going to probably come into evidence. As a general proposition. What I'm concerned about is that part you were just talking about in terms of satisfying 403 from a basic relevance perspective, and to avoid getting too far afield of the issues in the case is my general feel is I don't really want to get into relitigating the circumstances of the murders that Mr. Patton committed unless you can show me the specific reason that they would be relevant to this issue. And right now we're just having a general argument and you're just making a proffer, but that's what I haven't heard.
Well, I would reiterate the points that I just did. They're certainly relevant to how these bodies were disposed. They're relevant to who was killed and potentially why they were killed. There's evidence that Melissa knew about Carl Patton's murders, which is something he kept under tight.
But again, that's the fact of the murders, you're talking about the circumstances.
It's a motive for the murders, and it would be a motive for this murder as well. That's evidence of third-party guilt. It's relevant.
Mr. McDermott, I think we're talking past each other.
Okay, I'm sorry.
I'm not saying that you're right now, as a baseline guidepost general proposition here, I'm not saying that I expect the defense is not going to talk about the fact that Carl Patton is a convicted murderer. And I'm not saying that you're not going to cross-examine Ms. Patton about her involvement and that sort of thing. I'm also not saying that the fact that he's a convicted murderer might have some relevance to this case and whether whether Melissa had motive or whether that might have formed some motive for Mr. Patton to be this alternate theory of the crime murderer, right? That's not what I'm saying. What I'm saying is I understand Mr. Fawcett's argument to be, it sounds like you want to go in and let's have a little mini trial about the circumstances of each of those murders. And that's what I'm trying to figure out. Why would anything other than the fact that he committed murder, right? Even the numbers, even the names, but why would the individual circumstances of those offenses, other than potentially some leeway to cross-examine Ms. Patton, Norma Patton, why would that be relevant?
Well, can the court help me out here? Mm-hmm. When you say, oh, I lost my point, I'm sorry.
Sorry.
In the last thing you said. Obviously, we would agree that the fact that he committed murder is irrelevant. But you're saying what more than that is relevant? You're asking me what beyond that would be relevant in this case. And I think anything that okay, let me go back to the point. You're saying we don't want to relitigate this case. And you hear me trying to relitigate the Flint River.
Yes.
What part about me reciting the facts that are on court records in a guilty plea hearing, what part of that is relitigation? These are just facts about how those murders happened, what their motives were, who they killed. Those are facts on record, testified to under oath. There's no litigation happening. But those are facts on record that are relevant to the facts that'll come out in this case. And that is directly relevant to third-party guilt.
Okay. So, Mr. Fawcett, as I understand the state's motion, it was an effort to limit the nature and scope of evidence that will come in about Mr. Patton. Is that a fair general characterization?
Absolutely, Judge, that's correct.
Okay. So,
and let me just say this, if I may.
Sure.
I sometimes can miss things, but I don't know that we've received the transcripts that are being referred to by counsel.
Well, that's a different issue. Well, and when and if that arises, because I can't deal with all of these issues in a vacuum in the abstract, right? Some of these are going to have to come up in the moment, and that's fine. What I'm trying to do, which I think is the purpose of motions in limine, is to give the party some general guidance about what's okay and what's not. And I think that Mr. Carl Patton's existence history and the fact that he was even briefly a suspect, the fact that Ms. Patton was allegedly involved in his murders or in cleanup, whatever, right? Those things are fair game, and I think that to the extent the defense, I think those things are going to be facially relevant and not overly prejudicial. What I am concerned about, though, is confusion of the issues and prejudice that might arise if we go too far into the granular details, absent a clear showing of specific relevance of those details into the details of the killings committed by Carl Patton. And so that's my general guidance to you, understanding that as we start asking questions and get into the back and forth of actual witness presentation, you may satisfy me that it's necessary for you to go into the particulars of one or more of the particular killings by Mr. Patton. But right now, in a vacuum, absent a particular showing, a more particularized showing of relevance, I'm saying stay up here at the 50,000-foot level, and let's not get down into the weeds unless and until there's a showing that it's relevant for your purposes in this case.
So, just to be clear, what I've already mentioned about the motives, at least in two of those killings, to keep people silent who are going to talk about his murders, is that 50,000-foot level, or is that down in granular level, or where are we talking about? Because a general motive for killing somebody seems to me would be directly relevant to this case.
So I think you're asking me to conduct a sort of quasi 404B analysis, right? In terms of, I understand Mr. Carl Patton doesn't have any 404B rights in this trial, but
also that's been specifically talked about in the case law.
I understand.
404 does not enter into the analysis at all.
I understand. I guess my point here is I've given you, I think, what are the general broad strokes. And so beyond that, I think you need to conduct your examinations of your witnesses in the way that you believe is necessary, and I will deal with individual objections as they arise. Again, my point is Mr. Patton's crimes, that they happened, that he was convicted for them, that Ms. Patton was involved in them, I think those are all, we're all expecting those are going to be relevant and discussed in this trial. I'm just trying to avoid getting down into the nitty-gritty of it unless it's relevant and necessary for you. And if that's the showing that you're going to try and make, then I may agree with you. I'm just not going to do it right now.
Okay.
Okay? Anything else that we need to take up pre-trial?
Okay, the judge talking it through with the attorneys. How is Carl Patton going to come in? Remember, Carl Patton is the dad of the victim in this case. He's a serial killer. He's going to come up during this trial. To what extent will have to be dealt with by Judge Krause as it happens. He's the guy that's accused of the murder. He's the husband. Let's get a break. We'll get you in for the opening statements in our new trial. Plus, we're on verdict watch in the dismembered wife murder trial. Nicholas Kassotis, apparently he's sitting in the courtroom waiting for a jury question or verdict. We're waiting as well. Lots ahead. Stay with us.
Tom.
Welcome back to Court TV Live. I'm Ted Rowland's going to be with you on a Thursday. Opening statement set to begin at any moment in the killer daughter's murder trial for Christopher Wolfenbarger. He's accused in a cold case murder of his wife Melissa some 25 years ago. They're hashing out a couple final little details before they bring the jury in to be initially instructed and then for the jury to hear opening statements. As we wait, let's bring in our guests for this hour. Helping us through this, Adante Pointer is with us, along with Sonny Slaughter and Adante. The judge, Judge Krause, she seems really level-headed, assessing to what extent the Pattons, Carl Patton and Norma Patton, are going to impact this trial. But boy, you can tell the defense wants this to all be about a serial killer so that it deflects attention from the client.
Absolutely, they do. That's what the defense is there to do, which is to raise the prospects of reasonable doubt for the benefit of their client. And so what the defense is looking to do, they want the barn door to be open and to remain open from opening statements all the way through closing argument, so that the jury goes into that jury room and starts deliberating with the idea that this murder, this killing, may have been by the father, the convicted serial murderer, and not by this loving husband who just so happens to be sitting in front of you, about to pay the price for the sins of his father-in-law. Whereas the judge is looking at this and serving as a function as a gatekeeper. Her job is to make sure that evidence that is relevant comes in, but that irrelevant evidence, or evidence that is more prejudicial than probative, meaning evidence that's highly inflammatory but doesn't go to helping the jury actually make a decision on innocence or guilt, is kept out. And so the judge essentially said she's going to listen to the way the evidence comes in, and she'll rule upon how much evidence and how much leeway she's going to give the defense attorney as the case moves forward.
Sonny, this is an interesting scenario here. I mean, you've got not only the serial killer sitting in prison, who knows if they're going to wheel Carl in there in a, Silence of the Lambs mask, but you have the wife, Norma, who apparently helped him move the bodies and clean up. She's going to testify. If I'm a juror, I'm riveted by all this crazy talk of serial killing, and it is inherently going to deflect away from the state's case, is it not?
It is absolutely going to do that. And Dante was on point earlier with everything that he says. This case has a lot of complex nuances, and the amount of years that has taken to bring it forth, that complicates what the prosecution has to do. But the prosecution can also argue that the defendant also had this information in order to cloud the judgment of those that were investigating. He had knowledge of the fundamentals of the crime and all of the ways in which he could actually copycat the details of his murdering the daughter to make it like somebody else in the family did it. So these cases are complex, they're nuanced. The judge has decided to make, I think, which is a fair and balanced ruling, to decide as they go along and how the information is introduced. But as Dante said, the defense's job is to do what they do best, and that is to throw everything into the wheel and make it complicated for those that are driving forward to understand the direction of which best to go with the defense or the prosecution. In the defense of their client, they're going to do everything that they need to do, and the prosecution has just got to be ready and on point with what they have.
Dante, do you think that Norma, when she gets up there, the defense will try to get her from grieving mother to potential killer? I mean, if she's already helped kill other people, could she be a suspect? Could you throw that even at her to try to discredit her testimony?
I absolutely believe the defense will try to link her and throw dirt on her, which is real life facts, that she participated in these serial killings. And keep in mind, some of these victims were family and friends. So that means that no one ostensibly is off limits from that murderous couple. And now they have their daughter, who also was a victim and murdered. And so if the defense is successful in bringing in the fact that she participated, that there were family and friends, and I think what the defense actually were tipping their card to is the method and manner of concealment, and potentially the way people were killed is similar to the way the daughter was killed. Well, it's not a bridge too far to then have the jury looking directly at the potential killer or aider and abetter of a mom. And so the mother no longer is a grieving mom. Instead, She is a murder suspect that should be there sitting right next to the defendant, while the defendant actually is sitting in the gallery watching the mother and this convicted serial killer father be prosecuted.
Yeah, wow. And we heard that, from the defense that Norma is expected to take the stand today, so she might be leading off the state's case. Usually, yeah, grieving mom, perfect way to start a trial. This is a little bit more nuanced when she took part in a couple of these murders and like the cleanup, the actual in the living room, as we heard articulated there. Let's get a break. They're getting closer. The Judge Krause, she wants everything set before the jury starts listening to these opening statements. So let's get a break. When we come back, we'll watch the opening statements. There's the defendant. It's going to be a lot more about mom and dad than I think the husband. That's what the defense is hoping for. Stay with us.
A woman's remains found scattered throughout a 3-mile area.
Now, a former naval officer stands trial accused of killing his wife.
The dismembered wife murder trial. Live coverage today on Court TV.
There's some magic right there. Friday nights, the WNBA is on Ion. The Mystics battle the Heat. She was feeling it. Then, the Mercury hosts the Aces. Let's go, Aces. Coverage begins Friday night at 7. Find Ion wherever you watch. Ion, it's on.
Anything else that, there was a motion in limine that was filed by the state, I think last night. And I need some help with it because I wasn't quite sure I understood what we're trying to limit. Obviously, we've understood for some time now that the fact that Carl Patton is a convicted murderer, right?
All right, there you have the judge was talking about to what extent will Carl Patton, stay with us here, the serial killer, be part of this trial against Christopher Wolfenbarger, who is accused of killing his wife 25 years ago, his wife Melissa. Well, Melissa's dad was this serial killer. They called him the Flint River Killer. When you have a name like that, the Flint River Killer, that's legit. And Carl the Killer's wife, Norma, is also going to be part of this case. Here's a live look inside the courtroom. Apparently there's some sort of juror issue that has come up that may be pushing back the opening statements. We're monitoring it and listening in here as they go back and forth to try to nail down when this is actually going to be ready to roll, depending, I guess, on this wayward juror. Let's bring back in Sonny Slaughter and Adante Pointer. Sonny, the Flint River Killer Carl and his wife Norma. I want to play some audio, an interview Norma did, Patton, talking about Carl and how happy he was to find out that finally the husband, Christopher, has been arrested in this case.
Well, he was devastated when he found out she had been murdered, but he was deliriously happy as soon as he found out Chris had been arrested. Someone from the DOC actually went down to the prison to tell him personally, or he would not have found out until later in the week. And he was just jumping up in joy and called me as soon as he could get to the phone. As soon as they turned the phones on, he called me to tell me that he knew.
He's talking to our good friend Ashley Banfield over there at News Nation. Live look inside the courtroom. Sonny, I mean, it seems like Ma and Pa Kettle are still at it, and they're elated that their son-in-law is now facing the same fate as old Carl Patton, possibly.
You know, Ted, I was thinking, I said, what kind of family is this? And you know, they're still talking, and he was elated, and she was elated, and you really have to think, because they murdered members of their own family, I mean, what is going on here with these people? Like, this is very disturbing. On a very large scale, it's disturbing that this type of even behavior and criminal activity exists in our society today. And thank goodness, and you know, once again, kudos to the law enforcement professionals who were able to come together to find what did you call him, the Flint River Killer, and the accomplice wife, and now we have the husband. This is just outrageous. This is just ridiculous that they're doing this.
You see everybody standing. The jury is being brought in. They are going to be instructed, preliminary instructions before the opening statements, which is what we see in each of these trials. Adante, this seems like a very winnable case for the defense, because usually a cold case is difficult. 25 years is an eternity. We're talking witness recollection, et cetera, et cetera. And then you add this bizarro serial killer into the mix scenario. What's your take in terms of, just without hearing anything yet, it seems like prosecution might have an uphill climb here.
Well, I think the prosecution has an uphill climb no matter what in a cold case. just because of the length of time and the fact that the case had been investigated and leads may have not panned out to immediately focus in or enough evidence to actually arrest and prosecute somebody. At the same time, many cold cases turn on new technology such as DNA or genetic testing and or some other item of physical evidence, and in some cases even a new witness who either recants or testifies and provides new information that the cops and the prosecutors didn't previously have. Here, we've yet to hear the opening statements, and so we're not exactly clear as to what is up the prosecution's sleeve or what their strategy is that they're going to use to put this person behind bars for killing his wife. So it could be any one of those items of evidence, which may be the nail in the coffin, so to speak, in the prosecution's case against the husband. So, we have to wait to see, in particular, opening arguments should give us a very good idea as to the roadmap the prosecution intends to follow in order to get the conviction they seek.
All right, let's go in and listen a little bit to the judge here as she addresses the jury before the opening statements.
From this point forward, as you just came into the courtroom, you will only enter the courtroom through this door and only when accompanied by a deputy. So that means that when we need you to leave, the deputy will come and open the door for you and hold it while you go out. And when it's time for you to come in, the deputy will come in and announce your arrival. The deputies can also tell you a bit about our fairly meager offerings for lunch. I encourage you to consider bringing your lunch. We do have some options, but not a whole lot, and sometimes you'll be pressed for time. And I want to make sure that you do have an opportunity to eat and to make sure that you don't get hungry or distracted while you're serving as a juror. So I think all of you are wearing your juror stickers. If you would, make sure that you're always wearing those when you're in the courthouse.
Okay, we're going to break away from that trial to the other one, the other doozy in Georgia. The Kassotis jury has a verdict. Hour and 12 minutes. A lot of people thought it would be under 1 hour after listening to Nicholas Kassotis on the stand yesterday. The panel has come to a decision. The parties are gathering. Kassotis was sitting in the courtroom apparently during the deliberations. The prosecution has an office in the building. This is going to happen very quickly, according to our team there in Georgia. They say that all the parties will assemble and we will hear the verdict. The money is probably on a guilty verdict, but we'll find out. We need a break, so lots ahead. Do not go anywhere. We've got a verdict in Kassotis. We'll watch it together next.
Welcome back to Court TV Live. I'm Matt Johnson. I'll be your host this hour. And we have breaking news. We have a verdict in the Nicholas Kassotis case playing out in the state of Georgia. Let's get to the courtroom now. The judge is on the bench.
And ladies and gentlemen, please be seated. All right, sir, are you the foreman of the jury?
Yes, sir.
It's my understanding that the jury has reached a verdict.
Yes, sir. Yes, Your Honor.
Is it a unanimous verdict?
Yes, Your Honor.
Has it been reduced to writing?
Yes, Your Honor.
Have you signed and dated it as the foreman of the jury?
Yes, Your Honor.
If you would please hand the verdict form to the bailiff. I'm going to ask that the deputy clerk publish the verdict.
In the Superior Court of Liberty County, State of Georgia, case number 2024R-67, State of Georgia versus Nicholas James Kassotis. Count 1, malice murder, guilty. Count 2, felony murder, guilty. Count 3, aggravated assault, guilty. Count 4, concealing death of another, guilty. Count 5, possession of a knife during the commission of a felony, guilty. Count 6, possession of a tool for the commission of a crime, guilty. Count 7, possession of a tool for the commission of a crime, guilty. Count 8, possession of a tools for the commission of a crime, guilty. Count 9, possession of a tool for the commission of a crime, guilty. Count 10, possession of tools for the commission of a crime, guilty. Count 11, removal of the body parts from the scene of the death, guilty. Count 12, tampering with evidence, guilty. On this 14th day of August 2025.
Do the attorneys wish to see the verdict to make sure that it's in proper form?
No, Your Honor.
Are there any objections to the form of the verdict?
No, Your Honor.
Are there any other requests before we go into another hearing?
No request from the defense, Your Honor.
If I can just have one moment, Your Honor.
All right, so there you have it. You have Nicholas Kassotis, this former JAG officer, former attorney, found guilty on all of the charges, including malice murder, the top charge. So he is facing life behind bars without the possibility of parole. Not showing much emotion, now whispering with his attorney. His father also in the gallery, seated right behind him. Let's go back in.
Nothing concerning the jury, Your Honor.
All right. And does either side wish to place anything on the record before I excuse the jury?
No, Your Honor, and I also don't seek to poll, just for the record.
Nothing from the defense, Your Honor.
All right. Ladies and gentlemen of the jury, we've been here almost 2 weeks, and I wish to thank each and every one of you for your service. It is one of the highest forms of civic duty that any citizen can render to this state and this country, and we cannot resolve important cases like this without your willingness to serve. You've been diligent. You've been here every morning on time. You've been taking notes. You have done excellent work as a juror in this case, and it is sincerely appreciated, not only by me, but everybody involved in the criminal justice system. Your duty ends at this point, and I'm going to have to go into a sentencing hearing. There's one other thing that I do want to mention to you. I think you knew at the outset that this case was going to be televised, live streamed through various media outlets. And I want you to know that you have a right as a juror and as a private citizen. People may want to talk to you about this. Well, at this point, you can talk about it if you want to. That's totally within your discretion. It's my understanding that some of the media outlets may be outside. They may want to speak to you. That's solely up to you. I have no control over that. That's up to you. So when you see individuals who might be with the press or other outlets, that if you want to speak to them, that's fine. And if you don't want to speak to them, that's also fine. So there's nothing else I can tell you other than I sincerely appreciate your hard work in this case. I wish you well, and you are excused at this time. Thank you very much.
So there you have it, the jury of 5 men, 7 women returning guilty on all counts there in the state of Georgia. Here to discuss, I want to bring my guest in for this hour, trial attorney Kelly Hyman in studio, and also sticking around for the big news, Ted Rowland's anchor, Court TV. Ted, we'll start with you. Your initial reaction.
This was going to happen. I mean, his Jim McIntyre defense had obviously no resonance with this jury. It's interesting, he turned around and looked at his parents, I'm assuming his dad was in the courtroom, and he's got this like, I can't believe it. I can't believe it that they didn't believe my story. And you wonder, does he believe it? I mean, does he actually think that he went through all this because of the way he testified and his reaction here? She's just shocked.
Yeah, maybe a multiple personality type situation that we're dealing with, and maybe something like that will come out in any mitigation phase. Your initial thoughts, Kelly?
The jury definitely sent a message, and it was a very powerful message. They did not believe his testimony, and I think that's definitely key in this case. Whatever he was saying and what he said, they didn't buy it for a second. But you know, it's important to note that when you do testify, that is a very risky move, because either the jury's going to believe you or not, and then it also opens up the door for cross-examination by the prosecution as well.
And his testimony, how will that impact as we head into the penalty phase and fairly soon from now?
Yeah, it'll be really interesting to see like the ramification of that when someone actually testifies as well for that, and what exactly is going to happen and what the judge is going to do. But it's important to remember that one of the charges is malice, and that means that he had the intent. Like he thought about this, he planned this, and he really, thought this out.
You know, this convicted killer, Ted, sure loved to talk on the stand and weave that tale, that tall tale. Do you think that he's going to give a statement in allocution before the official sentence?
He may. He may continue on this road. Yeah, he's looking at either life with or without the possibility of parole, but because of that top charge, he's got a minimum of 30 years. So, I mean, it's...
Before being eligible.
Yes,
and then who knows what happens on the first go-around.
Absolutely. So he's likely going to spend the rest of his life in prison, and he knows that. He's an attorney. He knows exactly what is coming next, but the jury didn't buy a bit of this Jim McIntyre nonsense. And if you take, he's buying these totes on video, and he's there getting the totes, and her dismembered body is found in and around these totes in this hunting area. And it's not just his lies that came out. There was physical evidence here. The state had him absolutely
his car and his cell phone detected where the body parts were later found. Yeah. Also seen on video, surveillance video of buying the shovel. I mean,
so I think he had to take the stand. He was cooked. There was so much evidence against him So you might as well roll the dice.
So Kelly, how is everyone preparing right now? So we're about 10 minutes, 15 minutes before this all starts, the second phase. You know, what's happening behind the doors?
So the defendant is going to talk to his client. Obviously, we can see right now consoling with this. It looks like his family members as well, kind of going through that as well. But then also, defendants probably wants to talk to his attorney and seek advice about next steps.
Now, is that unusual? I don't necessarily always see a convicted person being allowed to hug someone in the gallery. That's strange.
That's really interesting to see that, and then also to see the attorney, you know, touching the gentleman in the uniform and stuff like that. That's really interesting to watch the mannerisms and the body language between the people as well. But potentially, the attorney asked, hey, he wants to go over and talk to his family for a second. Can he do that? Just to talk with them and stuff like that.
Do you think we're going to hear from the dad who was showing emotion in the gallery, supporting his son, who the son was accusing him of things in this trial?
Yeah, of not being his real father, not being his biological father. That was a whole other
abuse, or it did happen, didn't happen.
Yeah, that's why he changed his name. I mean, they seem to be absolutely supporting him. So maybe to your point, we do get maybe a mental health injection here during the sentencing phase from mom and dad, who may be watching in horror as they see their son, who, let's face it, had a fantastic military career and then a legal career after leaving the military. They may know exactly what happened in terms of a downfall mentally, and we may hear it here or not, looking for some sort of mitigation. It wasn't brought out at trial, and they allowed him just to go up there and spin this bizarro Jim McIntyre story. So maybe, but you see them, they seem to either believe his story or they know the entire story and are just heartbroken parents.
Yeah, that seems really compelling, because you always wonder, why did someone do something? What was the reasoning behind it? And is the parents know something that we don't know? And is this going to come out right now that potentially there was mental health issues and reached a point, and that's when things happen? It'll be really interesting to see what happens next.
This trial has been unlike anything that we have covered recently. It was kind of a shocker, you know, in what happened as it unfolded. So maybe we're going to get shocked yet again. Maybe he's going to actually admit it. Maybe he's going to say sorry. I just don't know what to expect with this guy.
Yeah, I doubt it, just because of his look of shock when the jury's verdict came in.
And shaking his head on the third charge of not guilty.
Yeah, I think he believes this Jim McIntyre thing, and I think he's still, who knows, but maybe the parents had know more, and some of that comes out here. One thing we do know is this judge is going to throw the book at him. I mean, when you have guilty from top to bottom on that amount of charges, to your point, that jury was sending a message, and this judge sat through the entire trial as well. I'm sure he's going to send one. Probably life without parole.
So, Kelly, who is getting ready right now? Obviously, the defendant will have a right under the Constitution to give his allocution statement if he chooses to. But then also, we are going to hear from the victims' families. Who else might we hear from? Any, other people that may have testified. The third wife that really...
Samantha.
Yeah, she was really taken aback on the stand and very emotional. She's victimized in a way. Could we hear from her?
Potentially, we could definitely hear from her. We could also hear from the defendant as well, and what exactly is he going to say? Is he going to say that maybe he had some mental health issues and that's a mitigating factor, or is he not going to say anything, or is he going to have like a statement already ready to go? Because potentially, I believe he'll appeal this. And so he wants to make sure that that record is preserved, and he says the right things that's going to help him with that appeal.
Okay, well, we are heading into that sentencing phase very quickly there in the state of Georgia. We're going to do this. We're going to fit in a short break. Coming up, we're going to head back to the state of Georgia for this sentencing phase as it gets underway for Nicholas Kassotis, who was found guilty on all charges. We also have Kelly Craft standing by. She was in the courtroom. We're going to have an update and all the coverage straight ahead.
Matriarch of the Adelson family gets arrested.
Donna Adelson is facing charges of murder, the death of her former son-in-law, Dan Markell.
Prosecutors say a bitter child custody battle was the motive for the murder-for-hire plot.
Now that Donna has turned into a defendant, what's next for the Adelson clan?
Now that the ship is
Council ready to proceed?
Yes, sir.
Okay. Everyone please be seated. All right, in case number 2024 R67, the jury having reached a verdict of guilty as to all 12 counts in the indictment, is the state ready to proceed with sentencing?
The state is ready to proceed with sentencing, Your Honor.
Is the defense ready to proceed?
The defense is ready to proceed, Your Honor.
Does the state have evidence in aggravation?
Yes, Your Honor. The state intends to call two witnesses and one statement that I will ask Ms. Ashdown, our victim witness advocate, to read. So the state would call, would the court like me to proceed?
Yes, ma'am.
At this time, the state would call Megan Mevin to the stand. Ms. Mevin will be speaking on behalf of the family of Mindi Mevin, Your Honor. Do you wish her to be there?
I'll let her, she might be more comfortable just sitting right there. Please raise your right hand before you're seated.
Do you swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. I just ran up the stairs, so sorry if I'm...
Just hold on. Just catch your breath.
Okay, let's see. All right. I've kept up with the entire trial and decided to drive 3 hours this morning to be here because I couldn't let this chapter of my life end without at least saying something. Unlike you, I have cried a lot over the last few weeks. My thoughts, anxiety, and emotions have been a roller coaster. They have been all over the place while having to deal with this trial. I go through anger, sadness, frustration, grief, stress, and every feeling that you can think of. You lived with us for 15 months with providing no financial contributions. 15 months that I will never be able to get back. At times when you lived with us, I told you how your actions had affected me, and this impact statement isn't much different. Whether you take away anything from this, that is not my intention at this point. You've shown no guilt and absolutely no remorse. You haven't even shed a tear. You thrive on the illusion of power and attention. You're a pathological liar, sociopath, psychopath, murderer. You thought you were so much smarter than everyone else, but you aren't. You wanted people to believe you were a victim of abuse, while you were the one being abusive, at least mentally. You have forever changed the meaning of trust for me and our family. I can no longer trust people in the same way as I did before you continuously lied and ultimately took Mindy's life. There will always be some questions that will go unanswered, but to answer them would mean to try to understand a murderer's mindset, and that is one I will never understand. Mindi was bright, beautiful, empathetic, confident, independent. She loved music and making others feel special. She always put her family and friends first. Once my husband Frank and I had our daughter, Mindi wanted to choose a name that was different than the traditional aunt name. She decided on Lulu. She was never able to hear her sweet niece call her that. My daughter was 5 months old when y'all moved in. She will never know the fun times they experienced together. I'm thankful my daughter does not remember the 15 months you lived with us and sat right next to her at the dinner table. My daughter will never be able to experience the love her Aunt Mindy would have continued to give her. Mindy was taken too soon. No one should have to live through the violent and gruesome murder of a family member. You're a very evil man. When I learned the news of what really happened to Minnie, some of my first thoughts were that I couldn't believe that evil man lived in my house in a bedroom next to my 5-month-old daughter. You have no remorse for what you did. This loss has impacted so many beyond our family. The emotional wound you have caused will never heal. We have comfort knowing she is in heaven now, free from the trials and scars of this earth. We have overcome hatred, darkness, and evil. She is looking down on us now, being proud of how we have overcome. We are done being victims. We are taking back our lives. Since I'm a science person, I'm going to quote Isaac Newton. Every action has an equal and opposite reaction. Our family believes you deserve the maximum sentence, life without the possibility of parole, because Mindy doesn't have a parole. You deserve to sit in prison for the rest of your life and think about Mindy every single day. Thank you, Your Honor.
Thank you.
Your Honor, at this time the state would call Morgan Paddock.
Thank you. You can raise your right hand.
Do you swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
There are people literally all over this world that have been impacted by Mindy's life, and I'm here to speak on behalf of them. I always say my worlds collided with Mindy. Not only was she my high school friend, but after moving to Savannah, all of my college friends became her friends too. My roommates became her roommates. My church group became her church group. This entire trial has rightly been focused on what happened to Mindy, but Mindy was so much more than what happened to her. She was a bright light, vibrant, generous, funny, caring, a defender of others, passionate, trustworthy, and so much more. If anyone in her life would have been in her position, she would be standing right here today speaking for them. Nick, you slowly and strategically tried to dampen her light, isolating her from the people she deeply loved, robbing her of time, laughter, creating memories and peace, always living in fear and isolation. She loved you and trusted you to tell her the truth, to protect her, to live out your marriage vows, and yet you were the one that she needed protection from. Her death has had and will have an eternal impact on those that loved her. There are dinner tables and holiday pictures and memories that will be absent of her. There are little girls growing up without their fairy godmother. There are friends who will always ache to dress up and go out for drinks again. Email inboxes void of her opinions on the latest happenings in politics. Friends who can't expect her to stand with them in their proudest and hardest moments. Friends who won't have her in the audience of their concerts or harassing them for their latest released music. My everyday life in Savannah is now filled with the awareness that my friend was living and suffering within walking distance of my house. And I never knew. I will never be able to drive down 65th Street, go to a Smoothie King, pick up meds at CVS, or buy tennis shoes at our local shoe store without being haunted by the fact that you were frequenting all of those places for 5 months while my friend of over 20 years was suffering in fear and isolation as I drove mere feet from her driveway. But it's not just me and her friends that will miss out. This entire world is impacted by the ending of her life too soon. There are compelling women whose stories she will never get to tell on her podcast. There is the beauty of the sound of her laughter, or the impact of her laughter, or the impact of her most fiercest eye roll. Your conviction can't bring her back. It just means that you can't do it to anyone else. But every person you heard from on the stand, and the many who are watching right now from a distance, will never stop keeping the truth of who she was and her memory alive. You may have taken her life, but you will never be able to take her legacy, and she would want you to know that today.
Your Honor, the state has one final statement that I'm going to ask to be read into the record. That statement would be read by Ms. Samantha Ashdown, our victim witness advocate, on behalf of Samantha Kolyesnik.
All right.
And the defense will object to the reading of that statement, as Ms. Kolyesnik, while obviously a victim of the circumstances here, is not a victim under the law that would be entitled to read a statement to the court.
But Judge, my position on that, as the court is aware, is that this is evidence in aggravation, not a victim impact statement.
It is, and I'll overrule the objection. Thank you, sir.
Thank you, Your Honor.
Yes. There's no need to swear.
To the court and to the Honorable Judge Rose, my name is Samantha Kolyesnik, and I am a victim of the defendant Nicholas Kassotis, aka Nicholas Stark, the latter of which is the name he used while victimizing me in Pennsylvania. You were able to hear my testimony against Nicholas during this trial, and you were able to hear and see my pain and my tears firsthand. I recounted his horrible acts of deception against me. I trembled taking the stand to testify. It was the hardest thing I've ever had to do, but I did it because I feel Nicholas is a true and constant danger to everyone he meets. I feel that if given the chance, Nicholas will continue to exploit, abuse, deceive, and harm others. I testified knowing I would be filmed against my consent and that I would be humiliated in admitting I was defrauded by a man I met online, and that my privacy would be forever gone. I testified anyway because I strongly feel and believe that Nicholas is a danger to society and that he must be held accountable. Ms. Bayo, ADA for the prosecution, mentioned ripples from Nicholas's dropping stone as an analogy for an impact of his choices. I am one ripple. I have not been the same since I found out about his deception from Agent Sands, and I will never be the same again. On the date of his arrest, when Agent Sands of the GBI told me Nicholas Stark was not his real name and that Nicholas had been lying to me, my entire world turned upside down. My sense of trust shattered. I felt humiliated, deceived, traumatized, and unsure if I would ever be able to feel joy or hope or trust again. I also felt stupid and will continuously be called stupid and gullible by some in the public eye, as a result of trusting a man who was once a naval officer, a JAG, an employee of the Pentagon, a man who had every opportunity and privilege in life. Everyone trusted Nicholas, and he knew it. and he privately relished and delighted in lying to them and in abusing that trust. He is a man who delights in deception, a man who thinks he's smarter than everyone in the room he walks in. I also felt terrified beginning on the date of his arrest and thereafter, and will forever be haunted by what he would have potentially happened to me if the GBI and Detective Jack Frost's team had not tracked, found, and arrested Nicholas Stark, aka Kassotis, when they did. I fully believe that the wonderful law enforcement agencies of Georgia saved my life that day, and I will be forever grateful to them for saving me from the evil man who goes by many names, one of them being Nicholas Stark. I was diagnosed with PTSD, post-traumatic stress disorder, as a result of Nicholas Stark's cruel actions towards me. I have nightmares, flashbacks, and panic attacks. I lock my bedroom door every night. I do not feel deceived by Nicholas Stark, aka Kassotis. I feel raped by him. I was not allowed to consent to a romantic and intimate relationship with Nicholas because he lied about his entire identity to me. There was no opportunity for true consent, and he ensured that with his vast network of lies. This is called rape by fraud, but unfortunately is not recognized in Pennsylvania, so all I could do was pursue an annulment on the basis of his fraud. I am sure Nicholas Stark, since he is a lawyer after all, knew those statutory limitations when he deceived me. I do not feel Nicholas feels 1 ounce of shame or remorse for his deceptions against many people, including those he perpetrated against me. He has sat in this courtroom and has attempted to make every mockery of it with his smug expressions, his arrogant demeanor, and his lack of tears as his victims, one after the other, have talked about how he deceived them. I beg and implore and plead to the court, please give this man the maximum sentencing. And please, if at all possible, by sentencing protocol and legislation, please do not allow this man to do paid interviews or in any way profit from his crimes. Nicholas, due to his sick need for control and his sadistic desire to humiliate and defraud others, will absolutely try to profit off his crimes in prison. Please do not allow Nicholas to write books or to sign movie deals or even take paid interviews. He must not be allowed to extract any more from the victims than he already has taken so much. I also ask that he not be granted any chance for parole. A man who lies as much as Nicholas has and will always be a danger to society, especially the most trusting and vulnerable among us. Sincerely, Samantha Kolesnik.
Thank you.
Those are the only evidence of aggravation that the state intends to present. Do you wish the state's argument, or do you wish to have mitigation
Wait till I hear
first?
from the defense.
Certainly.
Does the defense have any evidence in mitigation?
I'd just like to present the defendant's mother to testify in mitigation.
You may.
Father, I'm sorry, Father. One at a time. So, 2 witnesses, Your Honor. The defense calls Wayne Kassotis.
You can come up here, sir.
I'd prefer to be here, Your Honor.
That's fine.
Thank you.
Can we swear you in, sir?
Oh, absolutely.
Do you swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Absolutely. Good morning, Your Honor.
Yes, sir.
Heard a lot of things in this courtroom this morning. Last over 2 years have been hell for all of us, including Nicholas. Although I don't agree with the verdict that was reached in this court, that the jury reached, I do respect the process. They have no idea who Nicholas was. Nicholas is a kind, gentle man that has touched thousands of lives, both as a civilian and as a military person. Nobody saw pictures of him helping underprivileged children in South America as a naval officer. Nobody saw him helping friends as he's growing up. He is truly a wonderful, kind person. And from the beginning, when this all broke, from the lies that Agent Sand told to family members, we never believed that this was possible, and we still do not believe that this is possible. We know the person sitting there, our son, as a kind and gentle person that would not do this. And there's really no evidence that showed that he did. I just want you to be considerate and look at the man who he is and who always will be. Thank you, Your Honor.
Thank you, Mr. Kassotis. Thank you very much.
The defense calls the defendant's mother, Linda Kassotis.
And ma'am, you're welcome to stand here or you can go up there.
Stand here.
If you would please raise your right hand.
Do you swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Thank you. Your Honor, I would like to say first how incredibly sorry we are for Mindy's family that they had to go through this. We have never spoken since we heard the news of Mindy's death, but we feel incredible sympathy for them that they lost their daughter. But Nicholas was not responsible for this. We know him to be a kind and gentle person. As you know from the testimony, we had not been in touch with him for years through circumstances beyond our control, and every member of our family suffered as a result of that. People missed him so desperately. My mother said she had never gone a Christmas without seeing or hearing from him, and suddenly he was gone from our lives and we had no idea why. He is a good and kind and gentle person. The thought that he could take someone else's life is just unbelievable, honestly. I respect the jury's work that they did, but they got this one wrong. I'm sorry. Thank you.
Thank you, ma'am. Anything else, Mr. Weinstein?
No, Your Honor.
All right, at this time I'll hear argument from counsel.
Your Honor, may I?
You may.
Your Honor, this case is a case that the court has obviously spent the last 2 weeks present for and listening to all of the testimony. As a result, I don't plan to go over any of that. I think Morgan may have said it best when she described how Mindi and her life impacts the world. When a sentence is rendered, I think the court has always, and I think I've even heard you say, has to evaluate not just how it impacts the defendant, but the message of rehabilitation, if possible, versus punishment, if necessary. The law in the state of Georgia entitles on a murder conviction only 3 options, essentially: the death penalty, life without parole, or life with the possibility of parole. In this case, Your Honor, the defendant is additionally facing all of the additional crimes that can run consecutively. That would be the concealing death of another, which he faces up to 10 years, possession of a knife during commission of a felony, which is mandatory 5 years consecutive, although it could be, of course, probated. And then all of the counts of possession of tools for the commission of the crime that he's facing up to 5 years for each of those. And then the 2 misdemeanors are, of course, up to 12 months. That is more than what I would refer to as natural life. The state's position, Your Honor, is that the defendant should never be released from prison, that he is a danger to society, that his testimony before this court under oath was fraud, that he was dishonest, that he perjured himself, and that, of course, is the state's position. I'm sure counsel for the defense would disagree. And I think that goes to the question, however, of whether or not there is remorse or whether there is some validation to something less than life without parole. The jury has now determined that he not only killed his wife, but that he threw her out like garbage across 3 miles with the hope that no one would ever catch him. If that depravity could not be any worse conduct to deserve life without the possibility of parole, I don't know what could. But for the good work of members of law enforcement, all of the teams that worked so hard to run every detail down, we would not be here today. And so, Your Honor, it is the state's position that the defendant in this case should get the maximum sentence of life without the possibility of parole. The state will defer to the court with respect to all of the other counts, as I essentially believe that they are, you can't get more than forever. Thank you.
Thank you, Ms. Dale.
Your Honor, the jury has rendered its verdict. While obviously we don't agree with that, we understand that is your obligation to sentence him under that verdict. Mr. Kassotis is a highly educated man. He's a man that served his country honorably. You've heard a lot of testimony, not just from his parents, but from witnesses on the stand, of his kindness. I think there is an opportunity for rehabilitation in this case, especially given his past. So I would ask the court to sentence him to life with the possibility of parole. Those other counts that can be served concurrently, that the sentence have them served concurrently. I understand there's one count that must be consecutive. So that's the position of the defense, Your Honor.
Now, Mr. Weinstein, your client has the right to address the court if he so chooses.
Let me verify. He will not be addressing the court, Your Honor.
Then have him stand for sentencing. Mr. Kassotis, a jury of 12 citizens in Liberty County, Georgia, has now determined beyond a reasonable doubt that you are guilty of the offense of murder, along with 11 other counts. This jury has spoken very clearly. It is now my duty under the law to impose a sentence that is consistent with that verdict. And it's also my duty to look at the evidence and weigh the sufficiency of that evidence. And sir, the evidence in this case is supported by a mountain of compelling evidence. This case has revealed a level of depravity that truly shocks the conscience. To put together this elaborate scheme, this web of lies, creating this fictional character, Jim McIntyre, who does not exist. You wrote fiction, and your life was a fiction, at least the last 6 or 7 years. And then you carried out, or the evidence shows that you carried out, a brutal, horrific, gruesome murder of Mindi, someone who's been described by various witnesses as beautiful, kind, loving, vibrant, smart. And all of her hopes and dreams vanished in an instant. Her life tragically cut short by you. someone who professed to love her, to care for her. Just the ultimate betrayal. And then you desecrated her body in such a vile way, discarding her remains out in a rural area of Liberty County, hoping that they would never be discovered. This shows beyond all doubt that you have no conscience. When I described to this jury this morning the elements of the crime of malice murder, the language used in the Georgia statute is that the circumstances show an abandoned and malignant heart. That describes you. You have caused so much harm to your own family, to all of those who have been impacted by your deeds. This is truly a heinous crime. So the court has considered all the facts and circumstances of the case. And the court will now impose sentence that reflects the gruesome nature of your criminal conduct. As to count 1, malice murder, the court hereby imposes a sentence of life without the possibility of parole. Although you've been convicted in count 2 of felony murder, that count would merge into count 1. As to count 3, the sentence of the court for aggravated assault is 20 years to serve in the state penitentiary, and it runs consecutive to count 1. Count 4, concealing the death of another, the sentence of the court is 10 years to run concurrently to count 1. Count 5, possession of a knife during the commission of a felony, it's required to be consecutive, so the court imposes a sentence of 5 years consecutive to count 1. As to count 6, possession of tools for the commission of a crime, the court imposes a sentence of 5 years to serve, and that shall run concurrently to the other counts. Court will impose the same sentence on count 7, 5 years to serve, running concurrently. As to count 8, possession of tools for the commission of a crime, again, the court will impose a sentence of 5 years to run concurrently. As to count 9, possession of tools for the commission of a crime, the court imposes a sentence of 5 years, again to serve concurrently. As to count 10, possession of tools for the commission of a crime, the court imposes a sentence of 5 years to be served concurrently. Counts 11 and 12 are both misdemeanors. They carry a maximum sentence of 12 months. The court will impose a sentence of 12 months as to each count, counts 11 and 12, and they shall run concurrently. The totality of the sentence being a sentence of life without parole plus 20 years to serve. Sir, you have a right to seek post-judgment relief from your convictions of these crimes, and you can do that by filing a motion for new trial or filing a direct appeal to the appellate court. That will have to be filed within 30 days of today's date with the clerk of Superior Court in Liberty County, Georgia. If a motion for new trial is made and the court denies it, you will then have 30 days from the filing of that order to file with the clerk a notice of appeal to the appellate level. You also have a right to file a petition for habeas corpus, and that would have to be filed within 4 years of the date that the sentence and judgment in this case is deemed to be final. If you cannot afford an attorney to pursue your appellate relief, a lawyer will be appointed for you, and I'm sure that Mr. Weinstein will discuss with you all of your appellate rights. Is there anything else that needs to be placed on the record before the defendant is remanded to custody?
Your Honor, I just want to clarify. The court indicated life without parole for count 1, 20 years to serve consecutive on count 3, and 5 years to serve consecutive on count 5. Is that correct?
Correct.
Then that would be life without parole plus 20.
That is correct.
I just want to make sure the record was
I misspoke.
Thank you, sir.
It's mandatory by law.
Correct. I just wanted to clarify.
Yes, ma'am.
That's the only position of the state.
He is remanded to custody. Court stands adjourned.
Thank you, Your Honor.